All right, we are going to take a look at privileged communications. Our system is set up on the concept that what anybody says can and will be used against them in court. Even what they say can be used against them. There is a well-known exception, the Fifth Amendment, which says that I don't have to testify against myself. I don't have to make statements against myself, but if I do, they can be used against me. And that sort of boils down to that old saying, that old statement that the police say, you have the right to remain silent. Anything you say can and will be used against you in a court of law, and on and on. It's an advisory statement. A person can say, oh yeah, I don't want to talk then. And of course they have that right. So there are also some relationships that have a privilege, and that's what we're going to talk about today. Two things must be shown in order to utilize privileged communications. Number one, there must be a confidential communication that takes place between two parties. And number two, there must be an appropriate relationship between those two people that results in the privilege being enforced. Some of the other rules that go along with it: the statements must be relevant to the case that is at hand. All privileged communications are hearsay. Statements are admitted into evidence only if they are covered by an exception to the hearsay rule. If the privileged communication that we're talking about is in writing, that document must be authenticated, as we discussed in Chapter 7 or 8. It must also satisfy the rules on whether or not the contents of that document are admissible in court. So let's see. The most commonly used privileges are the attorney-client privilege, the husband-wife or spousal privilege, the physician-patient privilege, the clergy-impenitent privilege, and the executive privilege. There are some exceptions which apply to privileges. A person can always give up or waive their privilege. That example I used earlier, when the police say you have the right to remain silent, a little later in that statement they say, having that right in mind, do you agree to talk to me? Or will you talk to me? Or will you give a statement? Or they say, will you waive that right and give me a statement? So people have the right to waive it, and they can make their statement. Under those circumstances, that statement would be admissible. Someone can also give up their privilege by revealing information to a third party, and then that third party can testify to what was told to them directly. So here's an example. If a man tells his friend all of the details of a conversation that he had with his attorney, which is privileged, the conversation with the friend is not a privileged conversation. So the friend can be brought in to testify about what was said to him. Some additional privileges. The identity of police informants. If that privilege is challenged, the police and the DA might have to establish that revealing the identity of the informant would place that informant in danger. Some police personnel records, and some states have statutory privileges of their own that enable the media to protect their sources of information. We'll talk about that a little bit more later. Let's start with the attorney-client privilege. This privilege extends to the initial consultation, so if I go to see an attorney and I say things and I don't start a relationship with that attorney and go somewhere else, my attorney-client privilege remains intact regarding that conversation, even if they're not hired. However, I must be there in sort of an attorney-client official capacity. That is, I am there to seek legal advice. This privilege extends to the communications that happened and not what the attorney observed in that case. An attorney can be compelled to give the names of their clients and the dates of initial consultation, but again, not the reasons or the content of the legal advice. And it doesn't matter who ended up paying for the attorney, if my mom pays for it or something like that. Attorneys cannot discuss the case with a parent unless the child consents to the disclosure. In the cases of attorney-client privilege, it's the client who holds the privilege, and the attorney ethically must honor it. Clients cannot ask the attorney to hide incriminating physical evidence. In other words, counselor, I need you to hide the gun or the money until this thing blows over. If there's someone else present during the conversation who doesn't have the privilege, this privilege does not extend to what they overhear. The exception to that, of course, is attorney staff. They may hear things, and of course, they fall under the protection. A few more things on attorney-client privilege. It does not apply to planning crimes or helping the client commit crimes or perjury of a witness, including perjury by the client. An exception to the attorney maintaining the privilege is if the attorney has reason to believe that the client will inflict serious bodily harm or death on some specific person in the near future. The attorney has an obligation to report that. Just to be clear, conversations that are covered by the privilege, if the defendant confesses to his attorney that he committed the crime, the attorney is obligated to keep that confidential. And if the defendant tells the attorney about the case and then ends up hiring someone else, the attorney still has to maintain the confidentiality. Let's take a look at husband and wife privilege. There are two husband-wife privileges. One protects all the confidential communications that occur between a husband and wife during their marriage. And the other part of the privilege applies when one spouse is called into court to testify against the other spouse. There is a privilege there, and it restricts the courtroom use of any statements made in confidence during the marriage, and one spouse cannot be compelled to testify against the other as long as they're legally married, even if they're not living together. A footnote: if a state happens to recognize common law marriage, California does not, the husband-wife privilege applies to that. Both the husband and the wife hold the privilege, and either one can invoke it, meaning they can use it. Here are some exceptions. Crimes one spouse commits against the other. The most common example is domestic violence. The husband-wife privilege does not apply in that scenario. And crimes one spouse committed against the children of either spouse or both. And spousal support doesn't apply there. And bigamy. What is bigamy? Bigamy is when you're married to one person and then you marry a second person while still married to the first person. Bigamy. Some states cover confidential conversations which occurred during the marriage, even after the marriage has ended. In California, the privilege ends when the marriage ends. It covers letters, phone calls, text messages, any communications that occur between spouses. A lot of states hold that the privilege also applies to actions. That is, for example, the wife sees the husband hiding some stolen property. The wife cannot be compelled to testify about that. If one of the spouses disclosed some of the privileged information to some third party, if it's their privilege, then they've waived their own privilege. But they can't waive their spouse's privilege by blabbing to a third party. Okay, physician-patient privilege. It's very similar to attorney-client privilege. The patient is the protected one, and as long as there was a reasonable belief that the physician was in fact a licensed person and they're licensed to practice medicine, then the protection remains in place. The purpose of this privilege is really to make it more likely that a patient will be completely honest with their doctor. Doctors can be ordered to give names and dates, but no information about privileged conversations. Here's an example of an exception. If someone seeks advice on how to plan or conceal a crime from their doctor, also information that a physician is legally required to report, like child abuse, child neglect, domestic violence, and so on. They're a mandated reporter, and that cannot be interfered with. The patient is the one in this case who holds the privilege, and the physician is ethically obligated to uphold that privilege. Clergy penitent privilege. A clergy member would include someone like a priest, a minister, a rabbi, a religious practitioner of some sort. A penitent includes any person who consults their clergy for spiritual advice, repents their sins or wrongdoings, seeking forgiveness from God from a clergy member. All confidential communications are covered. Both the clergy and the penitent hold the privilege. Both do. Exceptions can include criminal cases and always mandated reporting of child abuse. Media privilege. News media argued that their privilege is contained in the First Amendment, and the U.S. Supreme Court disagreed. If there is no privilege, a reporter can be subpoenaed to court and sworn in as a witness. A judge can hold a reporter in contempt of court if the reporter fails or refuses to answer questions. However, that's the U.S. Supreme Court, so it's federal. There have been protections enacted by many states. And let me just read to you briefly from page 299 of your textbook, because I think it states it pretty well. 45 states allow reporters to protect their confidential sources, either through statute or through appellate court decisions within that state. Congress has not enacted a federal shield law. As a result, each of the 11 federal circuits has developed its own case law on the topic. In about a dozen states, the media privilege is absolute. In other states, the reporter is protected from going to jail for refusing to answer questions about informants or other sources used to prepare a news article. Typically, these statutes make no distinctions on the quality or circulation of the medium. A reporter for the New York Times is on the same legal footing as one working for the National Enquirer or someone writing for the school newspaper. Pretty interesting. What is covered under those kinds of media shield laws are notes and identity of informants, and it is the reporter who holds that privilege. And finally, executive privilege. We're talking about elected people like the President of the United States. And going back to the 1970s, we had a president by the name of Richard M. Nixon, and there was a big Watergate scandal. And during the Watergate scandal, a federal grand jury indicted a number of people who were involved. They also named President Nixon, because he was a sitting president, as an unindicted co-conspirator in these crimes. The court issued a third-party subpoena called a ducis tecum, which is a demand to provide evidence like tape recordings in that case and documents. President Nixon moved to squash the subpoena on the grounds that the materials being requested were covered by executive privilege, preventing disclosure of confidential communications. In that Watergate case, the United States Supreme Court, specifically Chief Justice Warren Burger, rejected Nixon's claim of absolute privilege or executive privilege. And within hours of the court's denial of that claim of executive privilege, President Nixon resigned.
Therefore, I shall resign the presidency effective at noon tomorrow. Vice President Ford will be sworn in as president at that hour in this office.
These days, a district court judge will hold an in-camera hearing, that means in chambers, with no one else in there but the president and the president's attorney. And the judge will review the material that the executive branch claims is privileged. And the judge will issue an order detailing what, if anything, will be admissible in the criminal trial. And finally, police personnel files. The information withheld or protected are permanent personnel records on an employee. Police personnel files, they include internal affairs investigations. Those are confidential. Also, records concerning the performance, so basically evaluations of the officer and investigations of his or her conduct. And the law enforcement agency is the one that holds that privilege, not the individual officers. The law enforcement agency is also the custodian of those records. So that's where the law starts. However, there are exceptions. There's the Brady Rule, which means that the district attorney must disclose any information that's known to them that would be relevant to the defense, that would be important to the defense. The word is exculpatory, which means it would tend to weigh in favor of the defendant. The DA in California works with their law enforcement agencies and receives information on what's in police personnel files up front, so that when they do have a case where they would be required to disclose information, they already know what they have to disclose. The other route, and this happens quite a bit, defense attorneys petition the court to obtain or to have a look at the personnel file of the officer who was involved in arresting their client, the defendant. They're supposed to have some legitimate cause or upfront cause that makes them believe that there's some information in there. For instance, if it's a case where force was used against the defendant, or even more common, when the defendant is charged with resisting arrest, the defense attorney might come in and ask to see the officer's personnel records or any complaints of excessive force by the officer, hoping to show that the officer is the one who has this pattern of using excessive force and that their client was, maybe only defending himself or something like that. Many times, not always, these are fishing expeditions, and the judges see through that and don't allow the request to go forward. But in today's society, more often than not, the judges will at least hold the in-camera hearing and review the files. The agency has to bring those files physically to the judge's chambers. The agency will bring their own attorney, or the DA, or a city attorney, or county counsel, sit down with the judge and just show him everything that's in the files. Some judges just rely on the agency holding the records to disclose anything if there's something to disclose. So that is Brady information, and that concludes our review of Chapter 10. I'll see you in the discussion boards.